Welcome back to Module 6, Chapter 6, Sports and the Law, Legal Evolution of America's Three Major Leagues, 2021 update, drug testing and injury grievance issues. We've got a lot for you. Professor Erin Caputo, my colleague for many years now, is going to help take us through these updates. The Social Security offset, boy, this has really been a big problem. You've helped write an article in JSL about Article 39, the new way to treat on-field injuries to prevent them from getting into the court system. You and Chris Dubert wrote that last year, Erin. So you're one of the world's leading experts in this area. So why don't you take us through this benefits package and the Social Security offset? And boy, maybe there's not standing yet because we're not quite to 2024. A lot there. Just in this first.
Yeah, thanks for having me, Professor Carfagna. And to your point, I think we'll just start with the concept of what the Social Security offset is. And so essentially what that means is that, once you are entitled, as a retired NFL player to certain benefits, once your Social Security kicks in, that amount that you'd be receiving under Social Security will be offset from the amount of money that you should receive or should be entitled to receive under your NFLPA benefits and retirement benefits. So there was about 400 players that were really, really affected by this after the last NFLPA, CBA ratification in March of 2020. And so you see a few of these lawsuits coming out of this. And so this being one of them, two former players filed a lawsuit against the NFL and the NFLPA regarding these clauses in the CBA. And what they were really claiming is that there were breaches of ERISA and Labor Management Relations Act, essentially stating that the NFLPA, breached their fiduciary duties in negotiating, and coming to these sort of resolutions in the CBA with the NFL and the NFLPA, as we've stated here, and as they claim, they don't represent retired players in CBA negotiations, and so a few of their defenses here were just that. They don't represent retired players, and that in terms of what they're required to do under ERISA, they satisfied, right? They appoint someone to oversee and administer these plans, but they're actually prohibited from, getting involved in the oversight and the distributions of any amounts under these plans. So in terms of what they're obligated to do, they met that. They met that. So eventually, then, in December of 2020, while this suit was still outstanding or still proceeding, the NFLPA announced that them and the NFL essentially decided to push back and defer the effective date of the Social Security offsets here from January 1st, 2021 to January 1st, 2024. And the plaintiffs in this case essentially said, well, that there are other claims in our suit that relate to things other than the Social Security offset. And again, here there's points that the NFL and the NFLPA agreed to. A few other things, fair access to the neurocognitive benefit. But essentially, once the motion to dismiss came up, judge essentially dismissed it without prejudice, stating that after they're able to refile after fixing deficiencies, but essentially. This claim wasn't ripe anymore, considering there had been no injuries, considering the Social Security offset won't take place until 3 years from now, not January 1st, 2021. So that's where we're at there. Again, relatively in the weeds type stuff, but I think when it comes to some of these benefits, again, I think that one of the big takeaways here that the NFLPA has asserted is that they don't represent retired NFL players in CBA negotiations, and nor does any league represent their retirees. And so essentially they had satisfied any duty they had to negotiate on behalf of their own players, and were within their rights under collective bargaining to come to these resolutions with the NFL Management Council.
And Erin, I think that's a great summary. It comes back to LMRA section 301, page 194. We're right on the middle of it now. And that is, look, if you've got a grievance relating to an interpretation of the CBA, that belongs in final binding arbitration. It doesn't belong in the courtroom. The only wild card here is we're dealing with retirees. So they were no longer at parties. So which way did that cut? That cut against them because they had no standing, or And Erin Savoie, I remember you asked about this last year. Well, wait a minute. Then what relief is left to retirees other than take a bad deal if it's done to them? And so this remains a live case, and I think we'll keep following it. A very good summary. Thank you.
Yeah, absolutely.
Yeah, we got again, Ninth Circuit. Here we go. The retirement board. Hey, they said what they said, and you're stuck with it, pal. I mean, it's read it and weep, just like the painkiller litigation. It keeps being killed and then brought back to life, and killed and brought back to life.
Right here, this was a bit
very tough to get outside of final binding arbitration on these grievances.
Yeah, I'll say this case here with Charles Demery was a bit interesting though, in that Ninth Circuit essentially said, again, they're not going to make any decision on this case, but they remanded it back to the board for review, considering there was some sort of I think the exact term that they use is right. There was no meaningful dialogue in terms of delaying benefits, and that they kind of reviewed Demery's appeal, in secret without him there, and didn't allow him to participate in that conversation as part of full benefits. And this is and so it went back to review again. And this has already been actually sent back to review multiple times in the past for things similar to this. In one case, they didn't allow Demery to provide any of his own individual evidence from any of his own doctors in terms of what the retirement benefits under the TMP policy should actually be. And so again, it was sent back for review for the board to review. And so this isn't the first time this has happened here. Just but this is, again, it's an example where it's not going to get outside, but it can be ordered back for another review and consideration if there's some sort of inherent problem in the arbitration or the review process, I should say.
And we'll have Chris Nowinski to talk about the concussion litigation. That's page 189. But again, you run right into section 301, and also at page 189, Article 3, Section 2 of the NFL CBA, the waiver of the right to sue. So, these are things that, again, keep running. This preemption is a different kind of preemption under Section 301. It is LMRA Section 301. Makes all grievances go back to final binding arbitration. Okay, keep going. A painkiller. It's another one. Keep trying to escape the LMRA.
It's been trying to escape for years now. I swear, every time we do this chapter update each year, we have to talk about debt here.
You're right.
Yeah. So to set some of the background here, this suit, again, for Carfagna, to your point, was dismissed under Section 301 of the LMRA in 2014. After stating claims under, providing opioids and some of these certain substances to players were preempted and governed by the collective bargaining agreement. So this was ultimately dismissed, and then it was revived again. In 2019, I believe. And the reason for these getting revived is really kind of the duty and where that lies in terms of prescribing painkillers to these players. And so in some cases it's focused on the teams, and now we're really focused on the league. And it's mentioned here in this, there's right here, a voluntary undertaking theory of negligence is what this claim is really based on now, and essentially saying that the NFL controlled or had some duty to control and did not control some of these teams in terms of their ability to prescribe and give some of these opioids and prescription drugs to some of their players. And so a few of the arguments to try and get this out of Section 301 that some of these that Dent has lodged is that and we're talking about recent developments here, is that in 2019 the player, the NFLPA and the NFL instituted essentially a prescription management plan, where they have a board governing, how these were actually distributed, to how prescription pills and opiates were distributed to players. And so one of the arguments here is that, well, obviously this was just negotiated between the players in the league. Therefore, during the CBA that we played under, or that we're suing under, or the CBA that was in effect, when we sued, this was not included therein, obviously, because it was just instituted here in 2019. And then it was also implemented into it was adopted in the 2020 CBA. So essentially saying the same thing, right? Said this was never included in any previous CBA. It was most recently included in the 2020 CBA. So how could this be inextricably intertwined, or, with the previous CBA, or need interpretation of a previous CBA if it wasn't implemented into a CBA until 2020? And I guess you can go back and forth as to, in those prior CBAs, what was actually governed when it came to prescription pills and opioids, even it's not a specific set plan for itself. But those are some of the arguments to try and escape themselves from Section 301 LMRA preemption.
And thank you. And page 183 starts the painkillers litigation. So this is an update to all of this. And I think it's just important. So what we're talking about is preemption under the LMRA when an interpretation of the CBA is required. Okay, that's star caps, and that's very different. And Evans is there at page 184. And to get outside of this preemption that would require an interpretation of the CBA, that's a different LMRA preemption than the non-statutory labor exemption from antitrust scrutiny. That pertains to that which is happening at the bargaining table. All these claims now that we're in Chapter 6, they relate to grievances under a collective agreement and trying to get them outside final binding arbitration. And that ties in with your Article 39 article, Article 39.
Yeah. And
that you wrote about.
In Article 39 of the 2020 NFL and FLPA CBA, I mean, the amount of clauses increased, I think, from about 6 to 20, right? It's a complete expansion, and it exploded. We're talking about, again, what was adopted into the CBA of, prescription management and opioid, boards. We're talking about field safety review committees, things like that. And then we'll talk about, how that applies to D'Amico Ryans and Reggie Bush once you get into Chapter 6 as well. But all those things, taking care of as many of those in the CBA as possible to hopefully preempt any common law claims under Section 301 of the Labor Management Relations Act.
So once again, thank you. And Reggie Bush is at page 187. We're preempting common law claims under LMRA 301. And the non-statutory labor exemption is exempting that which happens at the bargaining table from antitrust scrutiny. Just want to make sure everybody understands that.
Yep.
Okay, and the concussion settlement, such as it was, is a pretty good summary of it in the book, starting at 189. And you've updated it beautifully. This race norming is terrible stuff. Chris Nowinski is going to talk to us about it, as well as a WWE concussion case. He was Chris Harvard, as we all know, back in the day. But what is this race norming and cognitive functioning, assessments?
Yeah, essentially it was two former NFL players that were trying to claim benefits under the concussion litigation, one being Najee Davenport, and essentially stated that they weren't owed the amount of money that they should have been owed based on race norming, which is essentially changing the baseline for these cognitive ability tests based on race. And so they were saying essentially because they were Black, the baseline was lower. They weren't able to collect as much money as they traditionally would, or they would had they been white. And so the NFL reviewed. This claim was ultimately dismissed, but the NFL reviewed and said they were going to do away with race norming, retroactively look at the previous claims and assess those under the baseline for white NFL players, both retroactively and going forward. They're going to use the baseline for white players as well, for all players.
Terrific. And unfortunately for those plaintiffs, the WWE concussion case, you take us through it.
Yeah, essentially, there was a few cases that tried to get revived here under the WWE concussion case. I think it was 3 cases that tried to appeal as a class, and essentially not much to do with the merits here, but these were essentially time barred. It was a little bit of a catch-22 in that they tried to appeal these cases, and the court said you can't appeal until the last case is concluded. However, when they went to appeal after the last case is concluded, they said you're time barred because you need to appeal within the amount of time after the first case or your case had concluded. So bit of a procedural issue there. But again, I'll let Chris Harvard take you through all the facts and merits of the WWE concussion case, because he's going to be the best person to be able to do that.
And we finish with talk about legal evolution. My goodness, we just wrote this and it's already out of date when we get to Josh
Right.
Gordon.
Right.
Again, PEDs, we looked at this in chapter 2. We're picking back up here, in chapter 6. We talked about lifetime bans. I guess no such thing because Josh is back.
Josh Gordon's back.
I'll touch
on Tyler Skaggs really quick too.
Sure, yes, please.
I skipped over that. So again, this was part of the update last year, 2020 update too. But in 2019, Tyler Skaggs, unfortunately passed away due to a drug. And it was fentanyl and alcohol overdose when, he's a former pitcher for the Los Angeles Angels. So passed away on a road trip when they were playing the Texas Rangers. So his family has recently filed 2 lawsuits, one in California and one in Texas, alleging that the Angels were negligent in allowing Eric Kay, who is actually a former employee of the team. He was a former communications director who was known to have drug issues. I think he had been checked into rehab actually a few times within recently before Skaggs had died. But what Skaggs' family is claiming is that Eric Kay provided him with the drugs that ultimately led to his untimely death. And as a result, the Los Angeles Angels should be held liable for that, under a theory of vicarious liability, and the fact that they knew about Kay and that Kay's boss, who is, someone in the front office of the Angels, knew that maybe some of this had been happening. And so that's what we're looking at here is, 2 negligence lawsuits by Skaggs' family and his estate against the Angels and Eric Kay.
Which again, it arguably gets into court rather than it doesn't require an interpretation of the CBA.
Correct.
I mean, this is a straightforward, you basically killed my family member here. So that's how it escapes. Yeah. Okay. Very sad case. Sorry, I skipped over it. Thanks and that refreshes the update that we gave last year, which was even more extensive.
Yeah.
Okay. PED suspensions. Take us home.
Yeah, here we go. Now these are relatively textbook, for lack of a better term. So all these suspensions, all the links and everything are set forth in the book and the updates specifically for the NFL, considering some of these were tweaked a little bit in the 2020 NFL, NFLPA, CBA. But we have Will Fuller and Bradley Roby suspended. This was at the end of 2020 and into 2021. Performance enhancing drug policy, very textbook under that. For both of them, again, Roby says that he used a product that was contaminated with a banned substance. Fuller states that he was prescribed medicine that the doctor said complied with the policy. It doesn't matter.
No. StarCaps teaches us strict liability.
Exactly, strict liability there. Josh Gordon, as Professor Carfagna mentioned, he is back. He was reinstated, late last week, and is now signed with the Kansas City Chiefs. So, suspended 8 times over the last 9 years, and now he's back in the league. And so again, I guess it's not directly related to this, but you will see it. I don't know. Professor Carfagna, have we made Chris and I's article available through Canvas for this section? I don't know if we have. If not, we will. But there were some tweaks to the NFL's substance abuse policy as well in the last CBA, and just wanted to make sure to touch on that as we're talking about Josh Gordon, because that's continually what he was suspended under the substance abuse policy, and then some of when he was coming back and had some slip ups there. It was under substance abuse policy. So just want to make sure you're aware of the updates there. And, we detail those pretty well in that paper. Again, there's also, actually, if you guys want to look at it too, I printed out because it's super handy. There's a side-by-side comparison if you just Google it that the NFLPA published. So maybe a bit biased, but of the CBA side-by-side, it'll take you through a lot of these issues and give you the comparison between the 2011 CBA and the 2020 CBA. But I know we do that pretty well in the book too. Paul Campbell, this is MLB, and we talked about this a little bit last year in the update with Ryan with DHCMT, and this PED that's becoming I don't think it's more prevalent among players, I guess, in their intent to use it, but in a lot of these tests, you're seeing it a lot more trigger positive results, and so again, strict liability, suspended for 80 games under the MLB's substance abuse policy for his first strike. Again, he claims he doesn't know how this entered his system, but again, it doesn't matter, strict liability. And so when we're talking about the MLB, first strike's 80 games, second strike's 160 full season, and third strike is lifetime ban there. So that's where we're at in terms of the MLB suspensions for Paul Campbell. And Ramon Laureano, again, similar situation, 80 games for an anabolic steroid. That's just about as straightforward and textbook as you can get. 80 games for substance of a performance enhancing drug. Again, part one of the, of the 3-part suspensions we're talking about, performance enhancing drugs. So again, that's relatively textbook, but there you have it, Ramon Laureano.
Strict liability,
Yep.
It almost gets all the way back to commissioner's authority when you talk about Josh Gordon, it really does. And that's why it's all of a piece, go all the way back to the beginning, commissioner's authority, because really at the end of the day, it was within commissioner's discretion, right, to reinstate Josh
Yep.
Gordon.
Yep, had to apply back to the league, right?
Terrific update, everybody. Can't thank you enough for all the hard work you put in. I'm calling you Professor Caputo to differentiate you from Erin. So, and Erin said, well,
I think it's a compliment.
Ellie, thank you again for all the hard work you did over the weekend to prepare these updates. We'll have Chris Nowinski for this chapter 6 and take a close look at a lot of these issues again. But for now, we'll sign off, and thanks for your continuing attention.